The September quarterly meeting of Professional Advisors Group of the Catholic Foundation. Great group, good turnout, and we thank everyone for coming. I don't know if I seem to have known everybody here. Is anybody here that had brought a guest that they want to introduce? Yeah.
Adam Franklin is a fellow St. Catherine parishioner. He's up from Texas with UBS. Actually, he moved from Texas. He's not here for this event.
Okay. That was a special event. Yeah. Thanks for coming, Adam.
Thank you.
Anybody else? Well, great. Thanks. Thanks again for coming. Please, during the presentation and afterwards, feel free to grab refreshments. Reports from subcommittees, just real quickly. As you know, we've changed the structure of the group. They're now regular members and sustaining members. If you're not either, please let us know. Regular membership, there are no longer any dues or fees to pay. Sustaining members there is, and if you want to talk to either James, Craig, or I, or anybody else that's a member, we can explain more about that. Right now, our website is being changed. The new membership is the only sustaining members will be listed on the website. So that's either happened, Craig, do we know, or is happening now?
It is happening now.
Okay,
Yep.
great. Thanks. So if you want information that you haven't given us before, see Craig or one of the other staff members, and we can get that on as well. We want to pay particular attention to try to get some non-lawyers involved in the group. Jack Ryan's here for the first time, and so we've been a bit heavy on the lawyer side, and I think it would help both the group and also the foundation if we could get some non-lawyers to participate as well. So please mention it to colleagues or friends as they might want to join. The Speakers and Writers Subcommittee, Dan Brigardner is chairing that. We're now offering presentations regarding, I won't say a canned presentation, but there's a good PowerPoint that Dan's group has put together that we'll offer for parishes and high schools and that sort of thing. So if you know some opportunities for that group to do that, let us know that. Some upcoming events. You should have all received a invitation to the annual Solder seminar, the estate planning seminar that we put on now. Actually had an opportunity to look back when we started it. It was 1996. So we're coming up almost on 20 years. But this year will be on November 14th. We'll also be at the Boathouse where we were last year, there at the Confluence Park. We're really excited about the speakers that Dave Swift helped to put together. We've got Bill Reddington, the Chief Magistrate. I don't think that's still his position, but the Chief Magistrate of the Franklin County Probate Court. Bob Dunn, he's going to give us a presentation on the update on the court, like as we typically do. He also talked especially about the updated guardianship procedures that they're implementing within the last few months. Our own Bob Dunn will speak with regards to digital assets and clients being in the cloud and how that affects our estate planning and probating administration of the states. Dave Swift and Vic Ferguson will speak regarding basis step-up trusts. And finally, Ahern Slagle will talk to us about uncommon contested probate proceedings. So I think there's a lot of meat there. I think there's a lot of topics that would interest not only attorneys but also estate planners and financial planners and trust officers and that sort of thing. We have registration sheets. I think they might be in your packet for the solder seminar, so feel free, obviously, to copy that. If you know anybody else that wants that, or if they want their own, you can call in for that as well. Yeah, Joe.
So, Jim, I wanted to let you know that I'm the very first registrant for this. I've already registered with the front desk.
That doesn't surprise me, Joe's always one of the first, so thanks,
The
Joe.
last shall be first, and the first shall be last.
I didn't need to.
Our next regular meeting will be March 25th. Right now, we are, I should have talked to Dave, we're trying to line up the team from Dave's office that, have we solidified that? Why don't you explain what we're looking at?
Well, okay, yeah, there was a very recent Ohio Court of Appeals decision that our firm was involved with. I'm forgetting the name of it, but I'm going to think, a newcomer. That was what, yeah. Well, Emily, you know all about it. You ought to, she worked on this, but it had to do with the liability of a corporate fiduciary, and it's got a lot of good stuff in there about the standards to which a fiduciary is held, and the effect of exculpatory clauses. And what else am I missing, Emily?
That was the main two issues.
Right. So yeah, somebody, I think Beth's going to come, or somebody from that group's going to come speak on that.
So that should be really interesting. Please, as always, if you have a topic that you would like to speak on, or if you have a topic that you'd like to hear about, talk to Dave Swift or myself, and we'll try to put something together with regards to that. Finally, we've started a breakfast group. Steve isn't here, is he? I didn't see him come in. Steve Devlin.
Couldn't make it today.
Okay. Steve Devlin has agreed to chair a breakfast group. Initially, when we were kind of discussing it, we were thinking maybe young professionals would want to do it, but I think some not so young professionals showed up for the first time, and that's wonderful. We've had one of them, and we've got another one scheduled for October the 23rd. It's going to be at the Lane Avenue Panera's. It starts at 7:30, lasts for an hour or so. No, I'll say no structure, no speakers. You don't have to listen to me. You don't have to look at me unless I show up. It's just kind of to get together. There will be kind of, as you might imagine, maybe a 5-minute update with regards to what the foundation has been doing and that sort of thing. But we're real excited about that because while the 4:30 is convenient to a lot of people, it's not convenient to everybody. And so this might help generate some excitement with regards to our group and what we can do for you and have some network opportunities as well. So before I turn it over to the speaker, any questions about anything that I can address? Okay. Hearing none. Trust protectors have been used for many years. I know a lot of the attorneys in the room will attest to that, but it seems like we're really seeing a great uptick with regards to that. I'll let Emily describe what trust protectors are and what they do. But there are a lot of issues, I think, with regards to liability and duties and that sort of thing that I think Emily will address. Emily Pan is an associate in the Vorey Sater Seymour Peace Cincinnati office. So she did such a great job at last year's Sauter that we wanted her back. And as I told you then, she's farther than 100 miles from her home, so she's an expert. So we got an expert here. She focuses her practice on advising clients regarding a broad range of estate planning issues, including estate, gift, and generation skipping transfer tax issues, charitable planning and exempt organization compliance, trust and estate administration, contested trust and tax matters, construction and reformation of wills and trusts, and issues with closely held businesses and their owners. I don't know how we have any time for anything else, but Emily received her JD from the University of Miami School of Law and her BBA cum laude from the University of Miami. Dan Griffith was advertised to be here, and hopefully, nobody's real sad, but Dan came down with a case of the flu, and so I'm glad he didn't come, but Emily's going to take over for his side as well. So if you help me welcome Emily Payne.
Thank you so much for having me, and thanks Jim and Craig. And Craig, thank you for giving me a tour of this beautiful building. Last time I was in front of you all, we were at the boathouse, and today I'm actually in the Catholic Foundation offices, and it's very cool to hear the history, the first Wendy's, and all the local art. So thank you very much for that tour. So like Jim was saying, Dan is sick today, so I think he had some jokes planned throughout here. So I can't promise that I'll be able to deliver those jokes if I even know what those jokes are, but when you see the first slide, I think that was one of his jokes, so I'm just going to roll with it. So Trust Protectors is, like Jim said, is becoming, as I saw in an article today, the new kid on the trust blocks. Every time I turn around, I see an article about Trust Protectors, and there's a reason for that. The reason is, trusts are lasting longer. Now they can last several years, several centuries, even indefinitely. And the longer a trust lasts, the more changes that can occur during the duration of the trust. For example, changes with the tax laws, like we've seen recently, changes with respect to the beneficiaries, maybe their lifestyle changes, health changes, maybe they have substance abuse issues, things like that. There could also be changes with the trust assets. Closely held business stock needs to be sold, and it's no longer profitable to hold within the trust. Or maybe there's changes in societal norms, things that happen in society that the terms of the trust just are not relevant or current today. So because of that, settlers want flexibility in these trusts. They create these trusts, they become irrevocable at some point in time, if not immediately. And the settlers know that they cannot predict all the things that could possibly change during the life of a trust. Ohio law allows us several methods to change a trust if need be. Changes by agreement of the beneficiaries, changes by court-approved modifications. Now we're allowed to decant, which is where the trustee can exercise a power to distribute principal to a second trust and make changes that way. But now this new kid on the block, the trust protector, is an additional method for a settler to incorporate flexibility into a trust. So no longer are we stuck to this old model where it's like there's an older gentleman kind of leading the way with all these beneficiaries sitting around the table. No longer is there a single trustee who's overseeing the administration of a trust. Now we're seeing trust protectors also have a role within a trust. So under this traditional model, the traditional trustee has a variety of responsibilities, ranging anywhere from gathering and collecting the trust assets, communicating with investment companies, maybe they're even investing the assets, cleaning out and selling real estate, negotiating with creditors, providing notices to beneficiaries, sending them their annual reports, filing tax returns, pretty much any duty that is required to administer a trust, maybe even overseeing the administration of a closely held business, managing that closely held business. So under this old, or not old, but traditional model, the trustee is responsible for everything. And naturally, the more responsibility you have, the more liability you're going to be exposed to. A lot of times a settler wants to name an individual as trustee because they trust that individual. Maybe that individual really knows who the beneficiaries are, what their needs are going to be. Maybe it's a close friend or business partner. So this individual has, accepted the appointment as trustee as part of a favor or because they feel they have a duty to do so because of the close relationship. But before taking on this role as trustee, that individual really needs to consider, what does this mean if I'm serving as trustee? What's my role? What kind of liability am I going to be exposed to? And how is my conduct going to be reviewed? Because you know what? Beneficiaries are becoming more active in the courts these days. We are seeing a substantial uptick in the number of cases involving beneficiaries suing trustees over the administration of the trust and how the assets are invested and all things related to the trust. So a trustee is a fiduciary, and they are held to a specific standard of conduct that is required by Ohio law, that they must act in good faith. Acting in good faith is the duty of the trustee, and that cannot be drafted around. So an attorney or a settler cannot waive the duty of good faith. The trustee must act with a duty of loyalty as well to the beneficiaries, and there cannot be any self-dealing. And these duties have been in place for centuries, and they're defined by volumes of case law and statutes. So if you haven't already been asked to serve as trustee, or you are deciding who you want to serve as your trustee, think about whether you want to divide up responsibility. You want the trustee maybe to handle the day-to-day administration of the trust, but you want someone else to have the power to maybe make changes to the trust if those changes are needed. Maybe if there's a change in the law, you want someone to be able to modify the trust to take advantage of the new law or the changes in the tax law, for example. Maybe if there's a change with the beneficiaries, you want someone to be able to change the terms of the trust, to modify distribution provisions. So one of the new methods to modifying a trust is by appointing a trust protector. Not only can this trust protector have the ability to modify trusts, they can also supervise the actions of the trustee. So where the trustee is not behaving, so to speak, a trust protector can, for example, remove and replace them. So like I mentioned in the beginning, trusts need flexibility. So when the beneficiaries cannot agree on a proposed modification, or if the modification is such that a court wouldn't approve the modification, or maybe decanting isn't even available, a trust protector can add that flexibility into the trust, and they can hold any number of powers. There is really no definition of a trust protector. Some states have enacted laws specifically related to trust protectors, but Ohio is not one of them. In Ohio, we don't have a statute directly on point to trust protectors. However, we do have a statute that provides that a third party can hold a power to modify and direct a trustee to modify a trust or terminate a trust. And having those powers is essentially being a trust protector. Common law defines trust protector as anyone who has the ability to direct a trustee with respect to an aspect of the administration of the trust. I'd like to think that a trust protector's powers can be divided into three separate categories. The first category would be supervisory powers. The second category, administrative powers. And then the third category, modification powers. So I'm going to come back to this slide here. The powers to supervise involve anywhere from being able to remove or replace the trustee, reviewing and approving trust accounts, or directing investments. Again, there's no default or standard powers for a trust protector. It's really whatever the settlor writes into the trust. But these are just some examples of supervisory powers. Now, before you decide if you want to serve as trust protector, or if you're the one who's appointing a trust protector, what do you need to consider? So now I'm going to go back to this other slide here. You want to consider what is your standard of conduct, and what are you going to be responsible or liable for? Under Ohio law, a person who has the ability to direct a trustee with respect to a modification or the termination of a trust Ohio law presumes that third party or trust protector to be a fiduciary, which means that you must act in good faith and in the best interest of the beneficiaries. However, that duty of good faith can be waived, so you can draft around that. So the settlor can say, I'm going to name someone as trust protector, give them the ability to remove and replace the trustee, also give them the ability to direct investments of the trust assets, but this person isn't a trustee, or isn't a fiduciary. Well, when you're thinking about that, is that a good or a bad thing? And that's, really the question at hand anytime you're considering serving as trust protector or appointing a trust protector. Because if you're taking on the role as trust protector and you're accepting that role, you want to know, am I a fiduciary or am I not a fiduciary? Because if you're a fiduciary, now you must act in good faith and with the best interests of the beneficiaries in mind. So if you have the power, the supervisory power to remove and replace a trustee, what does that mean if you're a fiduciary? Does that mean you constantly, how do you monitor the trustee? Do you have to constantly be asking for trustee reports? You have to sit outside their office, watch every action they do. There's really no case law on this. There's no Ohio case law that is. There was one recent case that came out back in 2009. It was called the Robert McLean case. And in this case, that actual issue was at hand. Person created a trust, irrevocable trust for themselves. They named a trust protector. This trust protector had the ability to remove and replace the trustee. However, when it was drafted, the settlor said that trust protector must serve as a fiduciary. Well, this trust protector resigned, new trustees were appointed, and one of the successor trustees sued the trust protector later and said, trust protector, I want to hold you responsible for the failure, for the losses incurred inside this trust, because you should have removed that trustee. Trust protector said, well, what was I supposed to do? There's no instructions in this trust on how I was supposed to monitor the actions of the trustee. Unfortunately, that case, the court in that case, this is a Missouri case, didn't really analyze what that trustee or trust protector was supposed to do. So we really have no good basis to determine that if you are a trust protector and you're held to a fiduciary standard and you have the power to remove and replace the trustee, what that actually means. How are you supposed to monitor the role of that trustee? And if you have the power to direct investments, again, if you're a fiduciary, maybe that's easier. Maybe you just ask for trustee reports and you monitor the investments. But if you're not a trustee, let's say, or if you're not a fiduciary, now what does that mean? If you're the settlor and you're appointing a trust protector who has the ability to direct investments, but they're not held to a fiduciary standard, what does that even mean? I mean, do they just sit back and do nothing? Do they have to do anything? If the assets are just tanking, and they're not a fiduciary, they can just turn their head, look the other way, not do anything. Or what if they direct, horrible investments? Who's liable? Who do these beneficiaries, hold responsible? Is it the trust protector who's not a fiduciary? Is it the trustee who had to follow the directions of that trust protector? All these questions are kind of are unanswered right now. What about a trust protector with administrative powers? Anywhere from the power to, modify a trust if there's a change in the tax law, the power to change the principal place of administration of a trust, change the governing law, things of that nature are all associated with the power to administer. Here, if you are the settlor and you're thinking about appointing a trust protector, because you know that there's going to be changes in the law, this is a dynasty trust that's going to carry on for generations, you want someone to have that ability to change the terms of the trust to make sure the trust is still relevant, or to take advantage of tax changes in tax laws, things like that. So thinking about who you appoint as trust protector becomes very important. Now you want someone who knows what they're doing, who understands trust law, tax laws that affect trusts. So considering who you appoint becomes very important. They probably should have some special skill, special knowledge. Do you want this person to be a fiduciary or not a fiduciary? Again, same things to consider when we talked about the supervisory powers. If they're not a fiduciary, they don't have to act in good faith. They don't have to act in the best interest of the beneficiaries. Again, can they just sit back and do nothing? Then what's the point of even naming a trust protector? But if you appoint someone who has who's supposed to be who's the trust protector and is supposed to be a fiduciary, the trust says that. Now, is this person even going to want to serve? Are they going to be too afraid to act if they don't hold these special skills, if they don't understand trust law? Again, more questions and issues to consider. And here's where it gets really interesting. You know, a lot of times, a settler wants to make sure that they're leaving their assets to their beneficiaries and their loved ones in the best way possible, so that these assets don't hinder them and don't ruin them, that these assets actually help them and make their life better. While if you have a beneficiary who has special needs, or if you have needs, you know, to qualify for governmental benefits, or if you have a beneficiary who has substance abuse problems, or maybe develops substance abuse problems later in the future, having a trust protector is a really great way to kind of turn off and on distributions to these beneficiaries who may have special circumstances that arise where having distributions would really hurt them. Or maybe you have a beneficiary who needs excess distributions and the trust only provides for income and they actually need principal. Having a trust protector gives the ability to have an outside party make changes to the terms of the trust with respect to distribution provisions. Again, the question is this person a fiduciary or not a fiduciary? If they're a fiduciary, now they have to act in good faith with the best interest of the beneficiaries, all of the beneficiaries. So if they have the power to add or remove beneficiaries, force the trustee to make distributions, now they have to consider all of the beneficiaries. Are they going to be too afraid to act? Are they going to be too afraid to make decisions, to make changes, because they're afraid that they're going to get sued by the other beneficiaries? Because maybe one action is great for one beneficiary, but it's not for the other. So a lot of times, the settler is thinking, well, I won't hold them to a fiduciary standard. I'll name this trust protector, give them all these powers, and they won't be a fiduciary. Well, now you run the risk of, what if that trust protector just doesn't like one of the beneficiaries and, you know, holds back all distributions from that person? Maybe they even remove them as a beneficiary just because they don't like them. So the settler is giving a lot of power to one individual to do any number of changes to the distribution provisions if they're not a fiduciary. So anytime you're considering having a trust where you want to name a trust protector, the first thing you want to consider is, who do you name as trust protector? Does this person have to hold special skills? Do you name one person? Do you name a group of people? Maybe naming a group of people is the best method, because now you have, you know, maybe these people act by majority. Maybe you have a team of people that all hold special skills. Maybe you have a financial person, an accountant, a family friend. Maybe you have an attorney in there who understands tax laws, if that's the if there's going to be powers relating to administration. So after you decide if a trust protector is appropriate for the situation, the next question is, who do you name, and will there be successors? So when thinking about, you know, who you name as your initial trust protector, also think about, do you want there to be a successor trust protector? Is there a mechanism for appointing successor trust protectors? And then decide whether the trust protector is going to be a fiduciary. That requires them to act in good faith. Or if you're not going to hold them as a fiduciary. Now, what does that mean for your trust? Are you okay with that trust protector holding all of that power and not being held to any standard. And if you have been asked to serve as trust protector, you need to be considering these same things as well. What does that mean for you? Especially if you are serving in a fiduciary capacity, but also if you're not serving as a fiduciary, because what does that mean? So think carefully before accepting the role of trust protector. Okay, so there are obviously no jokes. So we can blame Dan for that. So I guess I'll just open up for questions. Yeah.
I'm not sure I understand why there is a need for two levels of authority here. Why, if you have these concerns about the trust being able to adapt to changing circumstances, presumably one, you're going to name as trustee or trustees people you trust. Why would you not provide that the trustee has these powers as opposed to a second party? And I guess as a corollary of that, if you make a trust protector not liable for fiduciary obligations, aren't you just creating a settlor that you have no control over and he or she can do whatever the hell they want with the trust?
Well, to your second point, that's exactly, the big question mark surrounding trust protectors. In a lot of articles I've been reading about trust protectors, you're exactly right. They're like the settler, controlling from the grave, so to speak. They have all the powers of the settler to do whatever they want. A lot of times, settlers are thinking, well, if I cannot hold these powers, either because A, I'm deceased, or B, because if I do, it's going to cause estate tax inclusion concerns. I want to be able to have someone to be my eyes and ears with respect to that trust. I want someone to, if I can't remove that trustee because they're not doing their job or we no longer like them, I want to have someone to be able to do that. So it's just a way of incorporating the settler's wants and wishes inside that trust, even long after they're gone.
Without any control over the trust protector.
Without any control, exactly.
Yeah, good luck.
Exactly, because, if they're not a fiduciary, they can, A, do anything they want, or B, do nothing. So then what's the point of having one? But again, there's, people want to have that sense of, well, I want to have flexibility with this trust. Because while Ohio law gives us the ability to change these irrevocable trusts through a variety of methods, they all come with costs. They may require the consent of all of the beneficiaries, and how many times are all the beneficiaries going to agree on something, especially if it has to do with beneficial interest. So a lot of times, those methods that are authorized by law don't work. Trust protector seems easy. It seems like, oh, well, you just name a third party, give them these powers, and it's done. But there's risks associated with it, potential costs, etc. Yeah.
I'll tell you where I used one recently. I used I called it a panel or a group where an institutional trustee may balk at. There was a beneficiary who had some substance abuse issues, and the settlor wanted to make sure that their money wasn't going to feed a habit. So this group, so I had the impression that the institutional trustee didn't want to be, the cop on the block in terms of making sure that the kid was clean. But this group of family members, we used 3 family members to decide whether he was clean or not. And if he wasn't clean, then it was, then he wasn't going to get any benefits, basically.
And the judgment was the trustee couldn't be trusted to.
No, it wasn't a trusted. It's an institutional trustee. I don't think wants to be in that business, and so we felt that an institutional trustee might balk at that kind of provision if they were given those powers. So,
That's very similar to a case that I'm working on right now, where I wish there was a trust protector provision in it. This was a very old trust. Grandma set up for the benefit of her children for their lifetime, and then at the death of the children, it would go to the grandchildren when they reached 21 outright. Well, the trust was divided up into separate shares, one for each child. One of the children has a son, one son. He's 39 years old, and he has severe mental health issues. He's manic, so he has very high highs, very low lows. Every time he is having a high, he goes out, he buys a bunch of stuff, he incurs a significant amount of debt, not to mention he has some substance abuse problems. Well, when his mom passes away, which is going to be soon, she's older, she has a lot of health issues, he is going to get this money outright. And there's no way we can, well, there are ways, but is he going to agree to a modification of that trust that says, keep it in trust, I don't want that $4 million? And so if we had a trust protector, it'd be really great, because then the trustees, or the trust protector, could just modify the terms of the trust that just turn it from an outright distributive trust to a lifetime trust for his benefit. But, so I'm working with the trustees right now on, what can we do? Can we talk to him? Can we convince him that it's in his best interest to continue the trust for his lifetime? So that was one instance where I was like, man, it'd be really great to have a trust protector who could come in and make those changes. Dave?
Yeah, well, first I wanted to second what Jim said. I'm involved with a case, same thing, with a corporate trustee that was very happy to have the trust protector in a substance abuse type situation. So I think that's clearly one good example of why you might want to do that. My question though really, do you want to comment on the possible use of a trust protector to add a general power of appointment to allow a beneficiary to get a basis step up when there wouldn't be one otherwise? And what's the liability of the trust protector if they do it or don't do it?
That's a great question, especially currently. I mean, that's so relevant. I mean, there's a lot of trusts now that were created when the estate tax laws were such that the exemption amounts were a lot smaller than they are, and spouses have died, and now assets are held in a credit shelter type trust where there is no basis step up. So if that spouse had a general power of appointment to appoint those assets, they could, get a basis step up if spouse is dead. So yeah, having a trust protector to be able to add that general power of appointment would be fabulous. But again, if that trust protector is a fiduciary, now what if they don't exercise that power? Are they going to be liable to the beneficiaries for not doing so? If they're not a fiduciary and they don't exercise their power, well then what was the point? So it almost seems like for powers like that, you would want the trust protector to have that fiduciary duty so that if it does make sense and it's beneficial to the beneficiaries, that they exercise and actually use that power that they've been appointed.
I'm going to assume, I'm not an attorney, okay? Trustees and the role of trustees, et cetera, are defined in law somewhere. Created the trustee when they created the trust. What created a trust protector?
That's a great question. So in Ohio, the trust protector is created under a provision that really talks about having a third party who is given the power to direct a trustee. So any person other than the trustee who can tell the trustee what to do. That's where we have derived this trust protector lingo. Common law, our statute concerning the power to direct a trustee is derived from common law. And when you look at the common law on this point, it refers to this term of trust protector. In trust protector, that term it's like a term of art came from these offshore trusts. When settlers, the only way to protect their assets from creditors was taking them offshore to a foreign trustee. Well, the settler was concerned, okay, my assets are in this faraway land. I have no idea what's going on over there. I cannot have any control over these assets, otherwise I'm gonna lose all creditor protection. So the laws in these foreign countries permitted the settler to name a third party to oversee and supervise that trustee in that foreign country. They could have, again, any number of powers, remove and replace the trustee, direct investments, all these things that the settler really wanted to do but couldn't do without blowing the whole creditor protection aspect of it. Well, the US, we really liked what we were seeing over there. We thought, hey, that's working out great. And there's a lot of times where, like we were just discussing, this could be beneficial for US trusts. And so the idea was taken from what we've been seeing as working in offshore trusts here in the States. And again, trust protectors is now becoming such a hot topic that other states are enacting specific laws with respect to trust protectors that are answering all these questions that I've posed to you all. What it means from the standpoint of liability, what standard they're held to, even giving them a list of set powers that they can hold. You know, Ohio is not going in that direction yet, but there are some, we've determined that there are some holes in the statute that could be fixed. For example, right now, you said, where does this whole trust protector concept come from? Well, it comes from a provision that says where a third party has the power to direct a trustee is presumed to be a fiduciary. Well, it's very specific in the language. It's a power to direct, where they're saying, I want you to do this, and I want you to do that. Well, what if your trust protector holds a power to veto, where the trustee comes up with the idea, you know, I want to distribute principal to this beneficiary for this purpose, but the trust says, trustee, you must get the approval of the trust protector. And so now the trust protector hears about this principal distribution, and they have the ability to veto that distribution. Well, what does that mean under Ohio law? Ohio law clearly covers a trust protector with the power to direct, but what about a trust protector who has the power to veto? Is that covered? Are they a fiduciary? Are they not a fiduciary? So that's a pretty big hole that we've found in current law. So another thing to consider. Yes?
Yeah, Emily, a couple questions. First of all, other than the junior with the substance abuse problem, what other situations do you see commonly that you could use a trust protector? And then secondly, how do you provide for their compensation?
Great question. So other scenarios, other than issues dealing with beneficiaries, one may be for changes in laws, tax laws. Like Dave pointed out, right now, current exemption is $5,340,000, adjusting annually for inflation, and you have a trust that automatically divides into credit shelter trust, marital trust, all for tax purposes. If you have a trust protector and maybe the division of the two trusts is unnecessary, the trust protector can change the trust terms to get rid of those formulas. So that's one reason for to address changes in tax laws. Maybe you want to have a trust protector in there who oversees the administration of a specific asset. So let's say the trust holds an interest in a closely held business. You know, family company, it's been in the family for years, now all of a sudden, family company isn't doing so great because all the family members are out of the company. You know, patriarch who's in charge of everything dies, passes away, children beneficiaries, not involved in the business, don't care about the business. Who runs the business? You have, maybe the settler wanted to have an institutional trustee to take advantage of all their, you know, in-house knowledge, but they don't have any wherewithal with respect to this specific asset. So naming a trust protector who has the ability, who knows about this business, maybe it's a business partner, they can get involved and directing the trustee on, let's sell this asset, you know, this is how it should be managed, directing things like that. Anyone?
Yeah, you had another question with regards to fees.
Oh yeah, sorry, fees, okay. Well, again, there's nothing right now in Ohio law that says that a trust protector should be compensated. But like all the questions I was asking before about who do you appoint, what kind of standard of conduct should they be held to, fiduciary, non-fiduciary? The next question is, should they be compensated? If they're not a fiduciary, should they deserve to be compensated? Because if they're not a fiduciary, they don't really have to do anything. They can just kind of look the other way. They can totally ignore the trust. They may not even know if they've been appointed trust protector in some cases. So should they get paid? Probably not, but maybe so. If they're a fiduciary and now they are held to a standard where they're required to act in good faith and in the best interest of the beneficiaries, shouldn't they be compensated just like the trustee who's also held to the same duty? What kind of compensation should they be entitled to? There's, again, there's nothing in the current statute that talks about that, but that's something that should be addressed in the trust agreement. So if you've been asked to serve as trust protector, you may want to ask, am I a fiduciary? Am I going to be compensated? And if you're really considering taking on that role, you want to make sure that the settlor and the drafting attorney are including these types of provisions in the trust, and it's explicitly laid out, so you know exactly the standard you're held to and how you'll be compensated.
Any other questions? Joe?
Okay, I'll bite. What's the significance of the shark?
Okay. I know
Call
this.
Dan.
Yeah.
Oh,
So Dan, he likes to have some sort of analogy to everything, and so he's like, Emily, trust protectors, aren't they kind of like like the ocean? I'm like, Dan, what are you talking about? The ocean? Trust protector? I don't get this. He's like, like you want to get in the ocean, you want to dive in, but you're not sure what's under there. It's like it looks great from afar, it's beautiful, it's blue, it's like endless possibilities of fun. But once you get in, you don't know if that water's going to be rough and shaky. You don't know what's going to be crawling on the ocean floor, touching your feet. I'm like, okay, yes, I get you on that. I'm like, it's kind of like, well, I guess that kind of works. Trust protectors sound great. They give you all this flexibility. But there's a lot of underlying issues that you just don't really see when you first hear trust protector. It sounds great, but underlying issues. So hence all the little shark and ocean references. So.
Let's thank. I'll take the chair's prerogative and ask you a question as well. Do we know of any legislation with regards to trust protectors or anything like that on the horizon?
Well, I will say I am on the Ohio State Bar Association's Estate Planning, Probate, and Trust Law Council, and I'm on a committee where this is being considered. So, more to come.
I agree with you in terms of, it sounds like kind of why aren't we letting the trustee do this? The thing is, we're seeing a lot of it. We're seeing more of it every day, and like anything else, when you see that, there's going to be some abuses or some things that have to be looked into.
Well, and a lot of times the reason a trustee can't hold some of these powers is because they are held to a standard. They must act in good faith, and they must act in the best interest of the beneficiaries, this whole duty of loyalty thing. So there may be some powers that if they exercise, that the settlor would want to be exercised, wouldn't necessarily be in the best interest of all beneficiaries. So, for example, let's say the trust says, divides into shares for children and all adopted children are excluded. Well, one of the children ends up adopting someone and now that child is excluded. Well, if the trustee had a power to add beneficiaries, how is you adding that one adopted child is beneficial to that child and the new grandchild, but it's not beneficiary to the other beneficiaries. Now their shares all been reduced. So there are reasons why the trustee can't hold some of these powers, because if they exercise them, they're not going to be able to hold up their standard care.
Another example of the trust protector we've used, John, and you were saying, I mean, it's the investment advisor that the family wants to continue to use. We've done that for years. I've never considered it to be a trust protector, but But I guess wouldn't fall into the definition as
Good point, yeah.
as loose as it may be.
And just another thing, just more food for thought. You don't have, trust protector is something that was commonly used with these offshore trusts, but a lot of times they're not even called a trust protector in the document itself. Maybe they're called a distribution advisor, maybe they're called a special trustee, trust advisor, investment advisor. There can, special friend, anything, really. You can call them what you want. The name doesn't really mean anything. It's really what's written in the terms of the trust. So, if you haven't been asked to serve as trust protector, watch out, you just might, because I read it, like in the article I read today that just came on my desk about trust protectors. It's the new kid on the block. So.
Well, thanks again, Emily. So, Doctor, you might have to have a shark in the background.
Yeah.
I don't know if there's any significance to that or not.
Jim, do you want me to get rid of it?
If you can. Craig Hepner would like to say a few words with regards to the foundation. And he would also like everybody to make sure that they take some of the snacks on the
Take
way.
the food home, please.
Yeah.
I'll be very quick. I know we're kind of going a little over here. I just have a few things. The first is some of you I've already met with one-on-one in this group, and I'm continuing to do that. James Anselmo is also continuing to meet one-on-one with professional advisors, our members of the PAG, and we're kind of updating you just in kind of that face-to-face setting on really what's going on with the foundation and just the different things that we're trying to bring to the PAG group and all that good stuff. So if I haven't gotten to you yet, or James hasn't gotten to you yet, we'll get to you pretty soon. I'm trying to get to the folks that we haven't seen for a few years first. So that's the first thing. And of course, always continue to think of referrals. People, friends, colleagues that you can refer to this group if they're in that particular industry. In regards to what's going on with the foundation, particularly in development, I only really have one thing that I want to mention. As it relates to our goals, we're doing very good. I usually kind of give you some numbers and an update and all that good stuff at these meetings. I'll kind of pass that to the next meeting, but we're doing very well. But specifically, one of the things that we're doing is we are really starting to bring to the front of what we do this idea of using life insurance as a way for people to plan and leave a gift at the end of their life. Lauren Brown, our president and CEO, makes no, he's very, very vocal when he says that he wants in the next 15 or so years for us to go from $150 million in assets to $500 million. And we know we're going to get there. But one of the ways that we're going to do that is really focusing on not just the gifts that we're bringing in throughout the year, but also planned gifts, gifts through people's estates, wills, all that fun stuff. And so life insurance is something that we've really started to work on and really promote with the foundation. So we've actually have some brochures that we just got a few days ago, and I put them over there on that table. If you're in that particular business, please grab them. Also, it's got just a lot of really neat ideas of all the different things that you can do with life insurance in there. And we're also going to be putting things in the Catholic Times, and we're going to be having a couple of seminars starting in the spring. We're also going to be featuring a story in our annual report on life insurance. So there's going to be all sorts of things that's going to be coming through with this whole initiative. But I just wanted to make sure that our PAG members understood that really when it comes to this, you guys are so important when it comes to referring your clients to us if that is the right thing for them. We really look to you for a lot of this, the key driver in terms of what's going to get us to where we want to go, especially with this initiative. So if you have any questions on that, come up and talk to me when this meeting's over and we can talk a little bit more about it, but you can check out the brochures over there. James, do you have anything else to add?
No, I mean, thank you for coming, and
Okay.
we'll be posting this online. This was just mentioned, so to all of your friends and everybody that couldn't make it, to check it out, so.
Any questions?
Can I make one last commercial? We ask how we keep Catholic education affordable. Well, we have our Catholic schools Virtues Gala. That's coming up on November the 5th. And right now, we're only meeting 11% of the need for tuition assistance within the diocese. So I would challenge everyone here to look to sponsor a table at our gala and to help out those families to be able to afford a Catholic education that don't have the means to do so. We raise anywhere between $140,000 to $200,000. It's the largest tuition assistance that we have, program that we have. So we'd love to have you there at the gala on November the 5th.
I've been to that. It's a very fun event, and you'll enjoy going. I also wanted to point out, a lot of times we get these folders, and we kind of take them back and throw them away, and maybe put them somewhere. Go through them. There is a lot of good materials. Our blessings in here. There's a piece on PAG with regards to memberships and things of that nature. So take a second and do that. One other thing that I wanted to again bring up is the ambassador program. I mentioned it last time. The foundation is trying to get kind of a face of the foundation in every parish. So if you're a member of a parish that doesn't have an ambassador, please see either Craig or James. Really isn't a lot of work, and it's mostly so that every member of the parish that knows you now knows who to call, and then you can forward the message to a staff member. But we're trying to get, I don't know how many, 25 parishes we have covered now, and there's 107 or 8 or whatever there is. So we're about a fourth through. And so if your parish doesn't have one, it's up to the pastor. But we're trying to make it even kind of a bulletin kind of position, so that you're named in the bulletin as the foundation ambassador to the parish. So that would help the mission and help get the word out. So thanks again so much for coming and taking an evening with us. And as I say, please feel free to take some snacks.